Young technology companies often have a plan to reach exit by being purchased by a larger company. M&A is an important exit strategy for early stage and venture-backed companies. But companies of all sizes that develop software and that contemplate future M&A need to have a solid understanding of open source software and of virality in open source software licenses because it's important in the M&A context. Why is that? Well, it is a standard procedure in the course of performing due diligence on a target company, some company that is a software developer that is being purchased by another company or into which new investment is being infused. During that due diligence, we investigate whether the company has made use of open source software for its internal uses or in the development of its own proprietary products, and we want to know how that software has been used. Even viral software can be used internally without creating viral effects. Software subject to the general public license, for example, might be used for internal purposes, but never incorporated within a product which is distributed to customers. And if that's the case, it's usually not a concern to investors or to a purchaser in the M&A context. But due diligence on the products in particular and any open source software which has been incorporated within it is of great concern to investors and M&A purchasers. If software has been used carelessly in that way, if it has been used in a viral fashion such that a company has been distributing source code or has been distributing software and now has an obligation to make the source code available, well, the purchaser may become disinterested at that point because the company has placed at risk its valuable trade secrets in its products. Now, how great that is of a concern for the purchaser is going to vary. Is it the single product and the entire business of the company that's been placed at risk? Is it one of many products? Are they less important trade secrets? All of those things have to be evaluated in context, but it is always the case that we want to know what commitments a company has made by virtue of using viral software, what commitments it has made in particular to distribute its own software products in open source form. A lot of companies are cavalier about this, figuring that they can clean up the situation at the time of due diligence. But bear in mind that if a company has previously used open source software, incorporated it within their own software, and the original software being viral, and then has distributed that previously to its customer base, that it has created a commitment to make available to those existing customers the source code of their proprietary software, their own developments. Even if that is changed, even if the product is changed at a later date or at the time of the M&A transaction, the previously created commitments still exist. And that's not always fatal to a transaction because the purchaser has to evaluate how much time has gone by, the likelihood that someone's going to ask for the source code, and whether the source code were distributed, it would actually create a concern. How valuable are the trade secrets in question in that instance? But it is always something that has to be looked at and should be managed all along the company's life cycle so that we don't have to clean it up at the time of due diligence when the transaction comes around. A solid understanding of open source software, in particular viral software products, in the use of in the development of the company's own products, is very, very important for companies that anticipate M&A in the future.